Hello, and welcome to the MeyerSuozzi podcast, a series of discussions from our successful attorneys giving innovative and creative insights on some of today's legal challenges.
Good afternoon. This is Paul Millis, and I'm here for another one of my podcasts. This one's going to be on an interesting subject that is on everyone's thoughts and lips, and that is, can you force your employees to be vaccinated? Well, let's discuss that a little bit. First, in terms of the law, I want to make sure that everyone understands that I'm not here to give legal advice over a podcast. When you have issues that may come up and everything is fact-based and then you apply the law, please do me a favor. Talk to your attorney, confer, provide all the information necessary for that attorney to help you make the right decision. I'm here to give you some basic information and to help you think about this particular subject. So we begin with the history of vaccinations. In 1905, in Massachusetts, a case came up to the Supreme Court of the United States, Jaccobson v. the state of Massachusetts, where they were dealing with smallpox vaccine, and they determined that because of a health emergency, the state could mandate under its police power someone be required to get a vaccine. So there is some history on this. There's also histories in terms of measles outbreaks and otherwise. Based on emergencies, as stated by the medical people, it has been from time to time absolutely a prerogative of the state to mandate certain treatment come about. Now, what does that do for an employer? Well, it gives you a little framework that vaccines can be deemed important under the law. Under the New York State Public Health Law, I think everyone's used to the fact that kids have to be vaccinated before they can attend school. That's certainly a requirement also in hospitals. Nurses and doctors have to get the flu vaccine, and if they don't, then certain precautions have to be taken, which quite frankly make their job very difficult to do under the circumstances. So there has been a history of this, but this is the first time where you really have a question of whether or not an employer can mandate certain medical treatment to its employees. Now we know that a couple weeks ago, the EEOC came out with a directive of some sort, or at least that's how it was played out in the press, that employers can require their employees to receive a vaccination. Now, if that were the case, our discussion would be over, and there'd be nothing further to talk about. But it's a little more complicated than that. First, understand that what the EEOC issued was a technical assistance in terms of questions and answers regarding COVID. There are 38 pages to this technical assistance, 13 of which are dedicated to vaccinations. The EEOC's directive is not a directive at all. It is nothing more than guidance. So it is not binding. It doesn't require the employer to do so. It simply gives its guidance that it believes that the employer can require an employee to receive a vaccination before returning to work. Now, only one case has been decided that I can find in this particular area. Bridges versus Houston Methodist Hospital. And in that case, nurses and some others had filed a lawsuit because the hospital mandated that they had to get vaccinated before they could return to work. The court, deciding mostly on state law issues, decided in a general sense, though, that yes, an employee at will can be required to receive a vaccination, and if that employer does not decide to take the vaccination, then the employee can no longer be employed. That's the takeaway from that case, and that was in the Federal District Court in the Southern District of Texas. One of the things the court dealt with that you should know about, because I'm sure you hear about it in the news, is the Emergency Use Authorizations, EUA. And what that means is that people have raised the defense that this vaccinations, or all the vaccinations that have been issued under an emergency use authorization, which is indeed true. And if one were to read up on emergency use authorizations, you would see that the CDC and the government authorities are required to tell the particular individual receiving the vaccine what the risks and benefits are. And then, quite frankly, give them the option of whether or not to take the vaccine, irrespective of what they've heard. So one would think that that's a great argument to make in court. The Southern District of Texas judge did not think so. In the end, he determined that that is simply a advice and counsel provided by the CDC in connection with emergency use authorization. It is not, in fact, something the private employer has to abide by in terms of giving the option to the employee. In fact, the court found that it did not increase nor decrease in any way an employer's rights vis-a-vis an employee. So it gave short shrift to that. I expect the issue to come up again, but if it doesn't bind an employer in any way, then of course at-will employment will prevail, and under those circumstances, you're going to be able to fire the employee if they refuse the vaccination. We've all talked about at-will employment. We know that you could fire a person for no reason or any reason at all, as long as it's not a discriminatory reason. So under those circumstances, it would seem to be that the answer is yay. You can, in fact, force your employee to receive the vaccine. But understand something. This technical assistance was written in connection with ADA claims or potential religious liberty claims. So really it's guidance to an employer to avoid being found liable under the ADA or under religious liberty clause. Let me deal with religious liberty first. We know that if an employee has a sincerely held belief, under certain circumstances, a rule that the employer imposes, such as head guards or clothing of some sort, cannot be enforced. Of course, there's still an analysis that one needs to do under those circumstances. One has to determine whether or not the belief is sincerely held. And I could spend hours discussing case law as to what it means to have a sincerely held religious belief. Then there's the issue of accommodation. So all of these issues that come up from the EEOC still are looked at under the framework of a disability claim or a Title VII claim, ergo religious freedom. Also, pregnancy discrimination. These things all have to be determined. Let me take pregnancy for a second. You got a situation where a pregnant employee may decide, I don't want to take the vaccine because it's going to be harmful to me. At that moment, the employer has an obligation. Obviously, there's data that deals with this, and it's fairly complicated, and who knows whether it's complete insofar as whether or not there's a risk to pregnant employees as a result of receiving the vaccination. But clearly, the employer has to engage in the conciliatory discussion with the employee in order to reach some sort of accommodation, if that's at all possible. Of course, that has a lot of issues that come from it as well. Whether you're trying to reach a reasonable accommodation in a pregnancy setting or whether you're doing it in an ADA setting, there are certain issues that you have to take into account. Will the accommodation allow the individual to perform the essential functions of the job? Who's to say? Depends on the circumstances. That's why talking to your attorney is that important, because everything is fact-based at that point. Then you have to determine whether or not there is still a clear and present danger or a serious risk of harm, irrespective of what reasonable accommodation could be reached. And I have to tell you, in light of the fact of how COVID has been viewed, and again, I'm not a doctor, but the bottom line is that it is viewed as a serious, and I used that 3 times, medical risk to people. Under those circumstances, I have to tell you, I'm not quite sure whether or not a reasonable accommodation could be reached, or whether or not a court might find that it can be reached. One would think it's possible in terms of that individual continuing to wear face masks, that individual being required to social distance, putting that individual in an office with no interaction. But can that person perform the essential functions of the job under those circumstances? Very difficult to know. Under the circumstances, these tests have to be performed in any circumstance where someone raises disability or raises a Title VII exemption to the enforcement of an employer rule under the circumstances. So it's not as easy as simply saying you're fired if you don't get the vaccination. What happens if the employee says no? Well, under those circumstances, we talked about in our last podcast how to terminate an employee, and all of those would prevail. But I have to say, I don't think there's any guarantee that we're going to be free from lawsuits as a result of this, and the EEOC's guidance is certainly not going to give the protection that it was portended to be when it was announced in the press in terms of what it really means to an employer. Now let's talk about New York State law. New York State law is broader in terms of its protections afforded for disability and for matters that fall under the umbrella of the human rights law, such as religious discrimination. And it applies to every employee. I'm sure you know that the ADA and Title VII apply to employers who in fact have in excess of 15 employees. In this situation, under New York State law, the law was changed in February last year to apply to every single employer. One employee, two employees, doesn't matter. That poses a significant burden on those employers to know what the rules are. And a lot of small businesses simply don't. They don't understand what their obligations are vis-a-vis the law, and they should. Now, since it is broader protections under the New York State human rights law, including but not limited to attorney's fees, which you can get under the ADA as well as Title VII, it's a significant risk if you don't look into this and deal with each employee's request for an accommodation in an individualized manner. In fact, you're required to perform an individualized assessment under the circumstances when an objection is raised by the employee in this particular area in regards to vaccines. Now, a couple bonus points that I'd like to bring to your attention. One, there is a bill in the New York State Assembly. It is in committee. I do not know whether it will ever get out of committee. I do not know if it will be passed, but it'll show you what the tenor of the times is. And I'm going to read a section for you. In this bill, it deals with COVID vaccination. And it states, if public health officials determine that residents of the state are not developing sufficient immunity from COVID-19, whatever that is, the department, meaning the health department, shall mandate vaccination for all individuals or groups, or individuals who, as shown by clinical data, I'm not quite sure where the data comes from, but that's what the bill says, are proven to be safe to receive such vaccination. I'm not quite sure if this will ever be passed, but I can say this. It shows you the push towards vaccination. And therefore, there will be built in some momentum for the employer to be able to do what it wants to do in terms of requiring an employee to be vaccinated in order to return to work. But that's not to say that 3 years from now it might be different and new facts might come out that will impact any ongoing litigation. So that's something to consider under the circumstances. A couple other points. One, pre-screening an employee by asking them whether or not they received the vaccination or not is impermissible. Now, it seems to be counterintuitive that if you could force your employee to receive a vaccine, why couldn't you ask a prospective employee whether or not they have been vaccinated? Here's the rub. Under the ADA, pre-screening of candidates is not permitted. You can't ask them about medical matters until such time that you have made a bona fide offer and to the extent that it's relevant to the employment. So it may be counterintuitive, but don't ask the prospective employee during the interview whether or not they've been vaccinated. You'll avoid a lot of trouble that way. Plus, the information you receive, in other words, you can ask your employees whether or not they've been vaccinated, and they are required to tell you under the circumstances if they have been vaccinated. However, you must keep that information confidential, like any other medical information that you receive from an employee. So the takeaway from all this is very, very simple. I would say you probably can terminate an employee if you have an issue insofar as a ADA or Title VII issue raised, or it's apparent from what the employee is saying to you. It needs to be dealt with. It needs to be individually assessed with that particular employee. Take it from there, and hopefully your decision in the end will be supported by the courts if in fact that individual sues, because as we know, you can't stop people from suing in court. So with that said, I hope this information was helpful to you. Next time, We're going to talk about those situations where you and your partner have decided, after serious consternation, a lot of arguments, that you just can't get along anymore and you have to go your separate ways. And no, I'm not talking about divorces in the sense of a husband and wife. I'm talking about business. We're going to be talking about business dissolution and shareholder rights in a series of podcasts where we discuss the rights and obligations of business owners to one another. And we'll be talking about how we end that toxic relationship so that everybody can move on and go on with their lives. With that said, I thank you for taking the time watching this podcast. I hope you have a great day and be well.